Good afternoon, I'm Yeng. Today, I'll analyze a legal dispute between State Arabica and State Botuna involving a bilateral treaty on a joint dam project. Arabica unilaterally suspended the treaty, claiming Botuna breached environmental safeguards. Botuna denies the breach, citing a fundamental change in circumstances and claiming that the access to clean water is now a jus cogens norm. This presentation evaluates the legality of Arabica's suspension, Botuna's defenses, and how principles like pacta sunt servanda, material breach, rebus extendibus, and jus cogens interact under the Vienna Convention on the Law of Treaties. Moving on, I'll briefly explain what is a treaty. It is defined under Article 2 sub 1 sub a that an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. From here, I'll briefly explain the principles involved in this case. Pacta sunt servanda is a basic rule in international law that means agreements must be kept. It says that once a country makes a treaty, they are legally bound to follow them in good faith. This principle helps ensure trust and stability in international relations, but it can be limited if the treaty goes against jus cogens norm. According to Article 60 sub 3 sub b, a material breach is a violation of a provision essential to the object and purpose of the treaty. The doctrine of rebus extendibus is enshrined in Article 62, which means the fundamental change of circumstances. To raise this doctrine as a defense to void or terminate the treaty, the change must be unforeseen, fundamental, altering an essential basis of consent, or radically transforming treaty obligations. However, it cannot be invoked if the change is due to the invoking party's own breach, and it is not applicable if the treaty establishes a boundary. In addition, jus cogens are the most important rules in international law that no country is allowed to break, like the bans on genocide, torture, and slavery. These rules are so strong that even treaties cannot go against them. If they do, the treaty is automatically invalid. Article 64 adds that if a new jus cogens rule develops later, any existing treaty that conflicts with it will become invalid and must terminate. Now, let's dive into the first issue of whether Arabica's suspension of the treaty is in accordance with the law. The Vienna Convention upholds the principle of pacta sunt servanda, meaning that every treaty in force is binding upon its parties and must be performed by them in good faith. Under the convention, a material breach of a bilateral treaty by one party entitles the other to invoke the breach as a ground for terminating the treaty or suspending its operation in whole or in part. A material breach is defined as either a repudiation of the treaty not sanctioned by the convention or the violation of a provision essential to the accomplishment of the object or purpose of the treaty. Article 65 lays down a procedure for a state wishing to invoke a ground for suspending a treaty, which involves first, notification. The party must notify the other parties of its claim, indicating the proposed measure and the reasons. The notification must be made in writing. Second, time period for objection. If no party raises an objection within the specified period, typically at least 3 months unless the matter is urgent, the notifying party may proceed with the proposed measure. If an objection is raised by any other party, the parties are obliged to seek a solution through peaceful means, as indicated in Article 33 of the UN Charter. So, for example, negotiation, inquiry, mediation, conciliation, arbitration, or judicial settlement. The UN Charter is binding on its member states. Despite the existence of a material breach, the parties are still bound by the requirement of notification to suspend a treaty under Vienna Convention. The court in Hungary and Slovakia held that in order to invoke material breach, the changes, whether individually or collectively, must be radically transforming the extent of the still existing obligations under the treaty. The ICJ reaffirmed the high bar for invoking the doctrine of rebus extendibus under Article 62. Furthermore, in a Namibia advisory opinion, the ICJ held that the treaty obligations do not simply lapse due to political change unless formally terminated according to international law. upholding the principle of pacta sunt servanda. Prima facie, State Arabica's suspension of the bilateral treaty is based on State Botswana's repeated failure to adhere to environmental safeguards, which Arabica's claims constitute a material breach by virtue of Article 60, Vienna Convention. For Arabica's suspension to be legally sound, it will need to demonstrate that Botswana's failure to adhere to the environmental safeguards amounts to a violation of a provision essential to the accomplishment of the object or purpose of the treaty. The significance of environmental safeguards to the overall object or purpose of a dam project treaty would be a key factual determination. However, it would be challenging for Arabica to suspend the treaty unilaterally without adhering to the procedural requirements of the VCLT. Therefore, Arabica's unilateral suspension of the treaty without giving a written notification to State Botswana within 3 months, and there is no dispute settlement raised, would likely be deemed illegal under international law. The second issue here is whether State Botswana's defenses under the Vienna Convention have a valid ground. Now, let's look at the Article 62 of the Convention, which deals with the doctrine of rebus extendibus, meaning a fundamental change of circumstances. A treaty may be suspended or terminated if a significant and unforeseen change in circumstances occurs. For this defense to be valid, 2 strict conditions must be met. First, the original circumstances must have been an essential reason why both parties agreed to be bound by the treaty. Second, the change must be radically transform the nature of the obligations that are still to be performed under the treaty. This means that not just any difficulties or inconvenience qualifies. The change must be fundamental and deeply affect the purpose of the treaty. The ICJ in Hungary and Slovakia clarified that even significant developments in environmental science and law did not qualify as a fundamental change that would radically transform the treaty obligations. In other words, those changes were not enough to justify Hungary's decision to terminate the treaty. Similarly, in the fisheries jurisdiction case between the UK and Iceland, the ICJ set a very high threshold. It ruled that a change in circumstances must result in a radical transformation of the treaty obligations, not just make them more difficult or inconvenient to carry out. The Free Zones case between France and Switzerland reinforces the strict interpretation of the doctrine. Here, the mere passage of time or inconvenience in economy does not invalidate a treaty, and the obligation must be respected unless both parties agree to amend them or unless specific legal grounds under the international law justify the termination. Overall, the court made it clear that the doctrine of rebus extendibus is interpreted strictly. A state cannot simply walk away from a treaty because circumstances have changed. At most, it gives a state a right to request a revision, renegotiation, or possible termination, but not to unilaterally repudiate the treaty without proper justification. On the other hand, a jus cogens norm, also known as a peremptory norm, represents one of the highest rules in international law. According to the Vienna Convention, it's defined as a norm accepted and recognized by the international community of states as a whole, from which no deviation is ever allowed. This norm can only be changed by another rule of equal strength. If a treaty conflicts with a jus cogens norm, it is considered automatically void, meaning it has no legal effect. This ensures that certain core values always override treaty obligations, no matter what states have agreed to. Notably, Article 10 and 13 sub 1 of the UN Charter stated that UN General Assembly resolutions are recommendations. Therefore, it cannot impose legally binding decisions. In ICJ advisory opinions, the court treated UNGA resolutions as evidence of opinio juris or emerging consensus, but not binding rules. Moreover, the court in Nicaragua and Western Sahara inferred the resolution as opinio juris and soft law. They are not strictly binding norms of law. However, they can serve as an evidence of an evolving customary international law. Based on the facts, State Botswana raises 2 main defenses. rebus extendibus, and the emergence of a new Jus-Cogens norm. Botuna may invoke Article 62 as a basis for renegotiation, but not for denying breach unless the climate change impact truly renders the performance impossible or contrary to original intentions. The outdated environmental safeguards due to climate change impacts would face a high evidentiary bar to prove they radically transform the extent of the obligations under the Dam Treaty. While the UN General Assembly has recognized the right to clean water, it has not yet been clearly established as a Jus-Cogens norm. Now, let's turn to the question of whether environmental obligation, such as the right to clean water, can evolve into Jus-Cogens norm and thereby override treaty provisions. Under international law, for any obligation to reach Jus-Cogens status, it must be accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted. Environmental obligations currently do not enjoy this status, but that doesn't mean they never can. In fact, the content of Jus-Cogens is not fixed. It is understood to be changeable, meaning new norms can emerge over time. While soft law instruments such as UN General Assembly resolutions are not legally binding, they can serve as an evidence of opinio juris, which is the belief that a certain practice has become legally obligatory. If enough states support and apply a particular environmental obligations in a consistent and legally firm way, it may gradually evolve into a Jus-Cogens norm. This is a high threshold and cannot be satisfied by soft law alone. There must be strong, consistent state practice and legal acknowledgement. Moving on, let's examine how the competing principles like pacta sunt servanda, material breach, rebus extendibus, and Jus-Cogens interact in this scenario. The principle of pacta sunt servanda is the bedrock principle, emphasizing the binding nature of the treaties and the importance of good faith performance. The Vienna Convention's strict procedural requirements for suspension or termination reflect this fundamental commitment to treaty stability. Material breach allows for a departure from pacta sunt servanda when the fundamental aspect of the treaty is violated by one party. It acts as a necessary exception to ensure that parties are not indefinitely bound by agreements that have been fundamentally undermined by the other party. Next, we have rebus extendibus. This is another exception to pacta sunt servanda. It represents a balance between the treaty stability and the need for flexibility in response to the changed circumstances, though applied very narrowly due to its potential to undermine treaty reliability. The Convention adopts a particularly cautious approach to the principle, surrounding it with far-reaching reservations. Finally, Jus-Cogens represents a higher order norm in international law. Unlike the previous exceptions, a treaty that conflicts with a Jus-Cogens is void and terminated outright, regardless of the party's intent. This demonstrates a clear hierarchy where norms considered fundamental to the international community override even treaty obligations. In conclusion, while Arabica may have a valid legal basis for suspension under Article 60 due to the material breach, its failure to follow the former procedure under Article 65 makes the suspension procedure invalid. Botuna's defense regarding environmental changes is not likely to meet the threshold given the strict interpretation of the doctrine by the ICJ. However, the status of access to clean water recognized by the UN General Assembly is not sufficient to be deemed as a peremptory norm, as it was not binding in nature. Thank you.